Dr. Darius Whelan was born in Limerick and educated at UCD, TCD and King's Inn. He's a lecturer in the Faculty of Law in UCC, and his research interests include mental health law and internet regulation. In his presentation today, he's just going to look at recent mental health case law. Thank you, Dr. Whelan.
Thank you, Martin, and thanks to Mary for that very interesting talk. And one of the things we always need to bear in mind, I think, is that the ECHR is a conservative convention, and we sometimes lose sight of that because it's the only one which you can use in practice, effectively, I mean, I think it's always very useful to have our eyes open to the fact that there are these much more progressive conventions out there, and in time, hopefully, they will start to have an impact in the courts. But at the moment, their main impact is at a policy level, and realistically speaking, those of you who are practitioners will know that there's only so much you can say about these UN conventions in a courtroom, I think we just need to bear that in mind. And those of us who have an influence on policy, not necessarily me, but the rest of you in the room, we need to keep banging on to the government about the fact that, and anybody who's in a position of power, about the fact that the ECHR is conservative. It brings us to a certain threshold of rights, which is great. It's a great improvement on the 45 Act and so on. But now is the time to move on from that argument and progress to a fuller realisation of full participation for people with mental health issues. So that's my initial response to Mary's talk, and I wish her all the best with Amnesty's campaign, and I hope to be able to contribute more than I was able to because I was busy with this little task that I was doing for the last few years. In terms of this talk, really the slides are there for reference. What I decided was that I'll go up to about slide 18 if I can, and I won't even read through the remaining ones. And so I have about 9 topics here on the next slide. And I'll deal with the first 6 of those, just briefly. I'm mainly looking at 08 and 09 cases, 2008 and 2009 cases. And for some of you, you'll be very familiar with these cases already. And for others, you'll never have heard of them. So it's the nature of a conference like this, and Mary made the point at the beginning, it's the nature of the conference. People have lots of different levels of knowledge. So I thought it would be useful for somebody to a kind of a black letter description of some of the main cases that have occurred in the last 2 years. There have been about 30 cases since the 01 Act came into force. So obviously I don't have time to go through each of them, so I've just selected a number of them. Also, I'll make the point that I will be using the legal terms used in the Act, such as the word patient, which I know is controversial, but that's the word I'll use, and also mental disorder, which is the term used in the Act. There is a very useful summary of the judgments which have been delivered since the Act came into force, available for free on the Mental Health Commission's website at the address given there. And it's quite reasonably up to date. There are only 1 or 2 that have been issued since that summary was done. And it's 60 pages long, So anybody who's interested in the case law, you can download that and you get a very good summary of it all. A key point which I think Anya Hines is going to come back to, and which has been very controversial for the Mental Health Lawyers Association and the legal representatives before the tribunals. I couldn't not refer to it, but I'll let Anya speak about it more. You are speaking about it, aren't you? A little bit. We have this famous quote from Mr. Justice Kearns in EH, where he said, "The fact that Section 17 of the Act provides for the assignment of a legal representative for a patient should not give rise to an assumption that a legal challenge to that patient's detention is warranted unless the best interests of the patient so demand." So the issue that arises from that quote is, does a legal representative, a solicitor basically acting for a patient, in making a decision as to whether to bring a challenge, do they have to look at the best interests of the patient? And some people might say at first glance, well, it's obvious, surely everybody who has anything to do with the patient must think about the best interests of the patient. But it isn't actually necessarily that obvious, because for one thing, as many people know, best interest isn't adequately defined in the Act, and even the Mental Health Commission admits that and says that it needs to be reformed. But for another, there may be a difficulty in conflict between the patient's best interests in a medical sense and their rights, their legal rights. And the patient, a lawyer's main duty, a solicitor's main duty is to the client and to advocate on behalf of their client. And introducing this reference to the best interest principle can muddy the waters as regards that key principle. So it has given rise to a lot of concern and debate within the legal community. Professor Anselm Eldrigill wrote two very good papers on the Irish Act, and he makes the point that Section 4 of the Act, which talks about the best interest principle, that from a textual interpretation point of view, it doesn't actually apply to the role of the legal representative. If you look closely at Section 4, it talks about the best interest applying as regards making a decision regarding treatment of a patient or detention of a patient. But a lawyer who's representing a patient isn't making a decision about their treatment or their detention. They're making a decision about whether a challenge should be brought if the law has been broken, which is a different type of decision. So it's a quote which is, as I say, a matter of great controversy, and it may have led to a reduction in the number of cases being brought before the High Court, which would be obviously of concern. The feeling is that the Supreme Court was laying down a marker that they didn't want a large number of challenges based on the Mental Health Act. But that would be of concern because, I mean, forgive me if I'm simplistic sometimes, but, you know, if the law has been broken, the law has been broken. And if a challenge needs to be brought, a challenge needs to be brought. And if that means that hundreds of cases need to be brought, well, then so be it. And in the immigration area, for example, there are hundreds of cases every year. And of course, the courts have tried to some extent to limit those cases. But it is of concern if the courts are laying down a marker that they don't want challenges, even if the law is being broken. Now, there have been two very interesting cases about the question of voluntary patients under the Act. The Act actually has a very strange definition of what is meant by a voluntary patient, because it says that under Section 2 of the Act that a voluntary patient is simply a person receiving care and treatment in an approved centre who is not the subject of an admission order or a renewal order. So as you can see, that doesn't require that the patient actually have volunteered. Even though it uses the label voluntary patient, it doesn't actually say that the patient must have actually consented to their voluntary admission. And the courts have latched onto that and said, yes, because it doesn't say that, therefore it could apply to somebody who doesn't have capacity to actually volunteer or be a voluntary patient, but who fulfills the wording there that they are simply receiving care and treatment in an approved centre. And this has been confirmed in... Did that jump ahead? This has been confirmed in two cases. Oh no, that's the correct slide, yeah. EH in St. Vincent's, which is the one which I quoted from earlier for other purposes. The patient was originally detained on an involuntary basis, then remained in the centre after the involuntary detention ended, and was classified as a voluntary patient by the centre. And the Supreme Court held that the patient was voluntary within the meaning of Section 2 of the Act during that period. And Mr. Justice Kearns also analysed the well-known case of HL in UK, which is also known as the Bournewood case. And he said that that case wasn't relevant, as in that case the patient wasn't voluntary at the outset. But again, that's a matter of debate. personally, I think that the HL case is relevant. And it's just distinguishing, as we say in law, you can distinguish a case. You can say that the facts were different, but you can use it as a device sometimes to avoid a precedent which you don't want to apply. And I think that's what the courts were doing here. The HL case, in principle, was very much applicable to this situation, but they avoided it through the device of distinguishing. And the same result was achieved in M. McN versus Health Service Executive, which was at High Court level rather than Supreme Court level, where Mr. Justice Peart again said, if you look at the last bullet point there, that HL versus UK was different, as Mr. L had been admitted on a voluntary basis at the outset. He also made a very interesting point about voluntary patients as well, which was that it would be grossly negligent for the hospital to bring patients to the front door of the hospital and say, off you go. Because one of the controversies about voluntary patients is, can you lock the doors of the unit on which they are, in which they are resident? He was laying down a marker that yes, you can lock the doors. As many people know, 90% of patients in approved centres are actually voluntary. And so again, this is another part of what we might call the second phase of looking at the Mental Health Act. Now that it has been bedded down to some extent and the tribunals are in operation, a lot of people are now looking at the voluntary patients and the injustice about of the fact that the Act doesn't actually deal with voluntary patients. And Senator Henry and others raised this while the bill was going through the Dáil. But unfortunately, the bill, which became the 01 Act, says very little about voluntary patients. There's also the interesting question of removals to approved centres. Again, many people will be familiar with the Act, but as part of the process, if you're detaining a patient involuntarily under the Act, it is possible for the clinical director to arrange for their removal, as it's called, by approved centre staff. So basically the idea is that an ambulance would be sent out in order to bring the patient to the centre if that's necessary. But that had to be amended to include a reference to what are referred to as authorised persons. And I'll explain why by looking at two cases. The first was RL in St. Brendan's in 2008, which was an application under Article 40 of the Constitution, which is often colloquially referred to as a habeas corpus application. And in that case, the patient challenged the fact that independent contractors were used rather than staff of the approved centre, and said, well, surely this is a breach of my rights under the 01 Act. And Mr. Justice Hardiman said, well, yes, it appears that Section 13 has been breached, but her later detention would still be lawful, because Section 13 is only one part of the process. Once one is removed to the approved centre, you still have to be assessed by a psychiatrist and admitted. And so Mr. Justice Hardiman said, well, that admission is still valid. Now, that, of course, seems very narrow in terms of reasoning when you first look at it, but you do have to bear in mind the remedy which was being sought here. Because it was a habeas corpus case, the court has a very limited role. It just says yes or no. Yes, the detention is lawful, or no, it wasn't lawful. However, if you take a more flexible remedy, judicial review, in the case of EF and St. Ita's, that remedy allows you to seek, for example, a declaration that the Act has been breached. And that was what was sought in this case called EF and St. Ita's. And the same situation had applied in the RL case, but this time Mr. Justice O'Keefe declared that the 01 Act had been breached. Whereas Mr. Justice Hardiman didn't declare it, he just stated it, but it wasn't part of his order. He said that prima facie it had been breached. But here we had an actual declaration that Section 13 had been breached. And this then led to an amendment of the Act. So that was great in a way, but it did demonstrate the inadequacies of habeas corpus as a remedy, or Article 40.4 as a remedy. And also shockingly, it took 2 years for a judgment to be issued in the case, and which therefore shows the inadequacies of judicial review as a remedy. And I know a lot of mental health lawyers, people in the Mental Health Lawyers Association would have cases where they would feel there might be grounds for judicial review, but they might feel that the defects in the remedy make it not worthwhile to actually bring the case. So there is a need to look at the remedies and to improve them in an ideal world, to improve them to deal with the problems which they raise. Turning to the power of Gardaí, as many people know, Gardaí have the power to take a person into custody under the 01 Act, and they had it under the 45 Act as well. They can only use it under what's called the harm ground of the 01 Act. They can't use the need for treatment ground, which is the other ground which is possible under the 01 Act and which can be used in other situations. So if, for example, you had a relative who wanted to apply for an admission order, they can apply either on the basis that the person is likely to cause harm to themselves or others, or on the basis that even though they're not likely to cause harm, there's a need for their treatment. But the guards can only use the harm ground. And then once they bring them, let's say, to the Garda station, they must then apply to a doctor for a recommendation for their admission. So they basically call a doctor to the station and get the doctor to assess the person. And there's been some interesting case law on the use of Section 12. For example, NZ and CATAC. In that case, the applicant had been taken into custody by a Garda under Section 12, but the application for admission was made by the patient's brother, the person's brother. Now that appeared to be a breach of the Act, because the Act clearly says if the guard takes you into custody, then the guard must make the application. But Mr. Justice Peart upheld this and said that he, in a way, he used a kind of an artificial device or a kind of a legal fiction, as we would say. He said one way you could look at it was that, well, the application for admission by the brother was the commencement of a fresh application, that the custody under Section 12 had ended at a certain moment, and then an application under Section 12 was made by the brother. And he did say, in an ideal world, the person should have been informed of this. But unfortunately, the person wasn't. But he said that even though the person wasn't informed of this, that it didn't invalidate the detention. Another interesting one was FW and James Connolly Hospital, where a detention was made by Gardaí on being phoned by a psychiatrist, and that was challenged on the basis that, you know, that might perhaps breach the spirit of Section 12, which seems to suggest that a guard would be on the street, for example, and notice that a person appeared to have a mental disorder and appeared to be at risk of harm. But Mr. Justice Hedigan held that the detention was lawful even in those circumstances. In SC in St. Bridget's, the Gardaí took the applicant into custody under Section 12, which, as you will recall, requires that the Garda apply the harm ground, that the person is at risk of harm to themselves or others. But the psychiatrist detained under the need for treatment ground rather than the harm ground. So the challenge then was, well, that this might be inconsistent. You know, if the guard detained under the harm ground, surely the psychiatrist should detain under the harm ground as well. But Ms. Justice Dunn looked at all the circumstances and said that it is possible for such a sequence of events to occur. This one is a recent case, Downs versus HSE. Unfortunately, the patient is named in the report, and it's on the court service website. And in this one, it involved the Mercy Hospital, which Dr. Lawlor mentioned earlier. In this one, the independent psychiatrist attempted to telephone a psychiatrist at the centre but got no answer, and he was told that she was ill. As you know, as many of you will know, as part of the procedure, once a patient is detained, an independent psychiatrist must examine the patient. A psychiatrist on the panel, the Mental Health Commission panel, must examine the patient and must interview the psychiatrist, the responsible consultant psychiatrist. Now, the tribunal, the MHT means the Mental Health Tribunal, was informed of this but decided that, as it had no doubt as to the patient's mental disorder, detention would be affirmed. And Mr. Justice Peart said that the failure to interview the responsible consultant psychiatrist before submitting the report was not such as to render the report invalid. Now, he's not necessarily giving a licence to independent psychiatrists to willy-nilly ignore this requirement, which is a very important requirement. He's just saying that in these circumstances where genuine efforts had been made to contact the psychiatrist and where there was no doubt as to the mental disorder of the person, and where the tribunal had all the facts in front of it, including the fact that the psychiatrist had not been interviewed, that if all of those boxes are kind of ticked, then it's possible for a tribunal to affirm the detention and for a court to uphold that. And then finally, the question of burden of proof. When we talk about burden of proof as lawyers, what we mean is, who has to prove what in a case which comes before either a tribunal or a court. And it's a very important question. And the Act doesn't specifically deal with the question of the burden of proof in the mental health tribunals. I talked there about the general principles on whom the burden of proof might lie. But in terms of case law, in England, English legislation originally required patients seeking their discharge to basically prove that they did not meet the standard of confinement. In other words, if you were a patient and you were detained, you had to prove that you did not have a mental disorder. And the English courts held that this was incompatible with the European Convention because it was requiring the patient to prove something. And so it appeared unfair and breach of Articles 5 and 6 of the European Convention. And they then passed amending legislation. Now, in Ireland, the main problem is that there's a specific section of the Act which says that if there's an appeal to the Circuit Court from a decision of a mental health tribunal, the burden of proof is on the patient. Basically, the patient has to prove that they do not have a mental disorder within the meaning of the 01 Act. And it's unclear whether this complies with the ECHR. You might think, well, surely it doesn't comply given that English case law which I just referred to. But the difference is that this is an appeal. So you can argue, well, it might be a breach of the convention to put the burden of proof on the patient at first instance stage, but maybe it's not a breach at appeal stage, because maybe an appeal is a luxury. And if the state grants an appeal, it can make it quite a restricted appeal if it wishes, because there's no requirement to grant an appeal. But there are counter-arguments, such as, for example, case law like Reid versus UK, which says that appeal courts should comply with Article 5. But that wasn't on the burden of proof point, however. It was just a general statement that once you have an appeal, then it should comply with both Articles 5 and 6. In the case, and this is my final slide, in the case TS versus Mental Health Tribunal, which is an 08 case, but many of us only became aware of it in 09 because it's an unapproved decision. That's another problem with the case law, is that sometimes you don't actually hear about, even if you're writing a book on it, you don't actually realise that a case exists until maybe a year or two after it actually happened. So they need to sort that out, somebody. But meanwhile, anyway, and I'm grateful to Maria Dillon, who may well be in the room, for passing on this decision to me. But in this decision, Mr. Justice O'Keefe, when the question of burden proof was challenged, he had to decide it, as they often do, under Irish law and under European law. On the Irish law, he said that the section doesn't actually place the burden of proof on the patient. He says that it merely states that the appellant must prove his or her case, which is what is always stated when an appeal is granted. But I don't agree with his interpretation there, as I say there. However, this interpretation is questionable. That's me speaking. He didn't say that himself. He didn't question his own interpretation. To my mind, I've looked closely at it, and it appears to me to be placing the burden of proof on the patient. And so I don't buy this argument that it doesn't do that. Then on the European Convention argument, he said that all the precedents which he had been referred to concerned first instances rather than appeals. Again, he's using this device of distinguishing, which I referred to earlier, which has merit. I'm not saying that you can't ever distinguish a case, but you must be very careful as a judge when you're distinguishing a case, only to do it in appropriate circumstances. But anyway, he said there's no binding precedent from the ECHR which says that it's unlawful to place burden of proof on a patient in an appeal, so therefore I don't have to rule that this is unlawful. Again, it's me speaking again with the however. However, once an appeal is available, the proceedings must ensure equality of arms. So I think that there's a clear breach of Articles 5 and 6 in the placing of the burden of proof on the patient. This was pointed out by people like Mary Keyes and so on when the legislation was passed. And I think it was even in the Shannon and Dáil debates. And it's been a problem that has been there from the very outset. And it's just a pity that when it comes before the courts and they have an opportunity to rule on it, that they give quite a narrow interpretation. So as I say, I'm going to leave it there because the rest of it is self-explanatory, hopefully. And also you can read the 60-page thing on the Mental Health Commission website and learn about all those other cases. Thank you.